Welcome, sir. Sir, today's concept is something like water on a lotus leaf. Can you please tell something about this? Nishkama karma. What is that? What made you to choose this as a subject?
I think the reason why this subject occurred to me when Keshav telephoned to me was that today we find the legal profession, the direction it has taken, is it's ceasing to be a learned profession any longer. It has become a crass commercialization. And the younger generation, probably in the next 50 years, they would not have even believed that it is possible. Like, what Einstein said of Mahatma Gandhi, in the generations to come, the world will find it difficult to believe that a man like him physically walked on the earth. So today what has happened is we need to introspect and think about our role in society and the role of lawyers and the great lawyers that preceded us and what kind of standards they set. Therefore, I thought this is a very important aspect, that you have to do your duty and it should stop there and end there. That's the reason why I thought of this.
Thank you so much, sir. Really, the topic has enlightened me. The name itself has enlightened me. Today's class is being taken over by Shri S. Naganand, sir, and he hails from a family of lawyers, and he's also a designated senior advocate, along with his father, who is also a designated senior advocate. And he has also started a law firm in his name, and he has been conferred as a living legend by the living legend in law by Bar Association of India in December 2020. He is who is carried 3 gold medals, and the sir is also a chartered accountant and qualified chartered accountant, enrolled as a professional chartered accountant. Even though being a chartered accountant, he chose law as a career and has started practice. And he is having 2 offices, one at Delhi and also at Bangalore. And I think many people could have learned from him who are associated earlier with him. And I request all the participants form part of this association and be to learn something from the world of Nishkama karma. So over to you, sir. Sri Naganand, sir. Please take over the mic, sir. We all will be blessed with your words.
Dear Keshav Sharma ji and Mr. Yagnadat ji, thank you for the kind introduction and the opportunity to spend a Sunday morning in legal fraternity. Apart from spending every day in front of the screen nowadays, we are also blessed to have the company of knowledge seekers, because today, life has become, what should we say, very difficult to understand, if I can use that expression. We don't know where we are living. We don't know what kind of life we are going to be leading in future. And all institutions that we thought of as existing for a particular reason, they've all become sort of topsy-turvy. So I think it is important for us to pause, think, introspect, and then see whether the direction we're taking is good or no. I always say, in many speaking engagements, I mention that, law as a profession, we have come a long way, there's no doubt about it. But the thing is, in terms of updation of knowledge, I must say that as a professional, we are woefully inadequate. And it is important for us to, pay attention to this aspect, because updation of legal knowledge is something which is very, very important. Unfortunately, the lawyers believe that if I qualified in 1950, I'm competent to practice in 2022 also. And therefore, in all other professions, we have updation of knowledge. Since nothing like that is happening at a statutory level, various organizations like this, Vestralex, and I know groups of many lawyers in Bangalore and elsewhere, they are doing this exercise as a service to their own professionals and as a service to society. I think this is a wonderful thing, and we must heartily welcome them and applaud all the people who are taking the trouble to organize this and getting people together to sit down and reflect. When Keshav telephoned me, out of the blue, he asked me, I would like you to suggest some topic. So it just occurred to me that we should talk about this subject, which is in the legal profession, what is the role of Nishkama Karma? You see, for Nishkama Karma, literally it means doing one's duty without having any expectation. Kama has several connotations in Sanskrit. One of them is desire or expectation. So Nishkama Karma means that. The background for this, if you see the Prasthanatrayas, which is the three main philosophical heads for Indian philosophical development, you have the Upanishads, you have the Brahma Sutras, and you have the Bhagavad Gita. Adi Shankara Bhagavad-pada has written commentaries on all three of them, and we are still in the process of trying to understand them because there are so many nuances of it. And the modern educational system that we have, the pattern that we follow, thanks to the British, we have completely obliterated our entire past history of knowledge that we have in this country. Whether you take Sanskrit knowledge, whether you take literature, whether you take fine arts, whether you take Bharatanatyam, whether you take Ayurveda, all of them is outside our normal syllabus. Many times people say, who is Adi Shankara Bhagavad-pada? I don't know, we never heard of him. After a person has finished post-graduation in India, that's the level that we have reached. So it is important for us to go back and see what did our ancients say. And I'll quote one sloka from Bhagavad Gita. Karmanyevadhikaraste ma phaleshu kadachanaha ma karma pala hetubhyo ma te sanghostva karmani. I think this is a shloka which many of us have heard. And it's a very simple sloka. Bhagavad Gita itself is very simple in language. So all that it says is, your duty is to do your job. Karmani eva adhikaraste. That is your duty, your right. But next word it adds, ma phaleshu kadachana. Don't expect anything in return. Now we have a similar thing in another shloka. Brahmanye adhya karmani sangam tyaktva karoti yaha lipyate na sa papena padma patra nivambhasaha. They give an illustration that just like how a lotus is in the water, but no water is attached to its petals because it is above the water, you must be in the same way. Sangham tyaktva means you must give up your attachment to what you are going to do from your duty. Now, if you keep these two slokas in mind and look at our profession, now I'll go from here to England in the medieval times. Many of you would have noticed that we have the system of wearing the lawyer's robes. There's a gown that we wear over our black coat and the band. And the gown has a small pouch at the back. And often, many times wonder, why is this small pouch there? And many young lawyers, when we ask them, they are also not aware of it. The historical perspective is that a barrister in English times was not supposed to ask for any fee. When a brief comes to him, he's supposed to go quietly, get ready, argue the case and come back. And when the work is over or whenever, if the client chooses, he can put whatever coins he wants to put in the pouch that is behind his gown without even telling this man what he is doing. I mean, that's the ideal that they followed. Now, of course, things have changed all over the world. Now, I'm not saying that having a desire to earn money is bad, but that is not the question. Now, we get one more indication of this in the Taittiriya Upanishad. In the Shikshavalli, which is like the convocation address, it says, Yanyana vardhani karmani tani sevitavyani. That means you should do all duties which you are supposed to do without any blemish. So that means you must not only do your duty well, your duty to your client, and often you would have heard this expression, lawyers are officers of the court. They have a duty to the court. They have a duty to their client. they also have a duty to society. If you go back in times during the freedom struggle of our country, I was reading an article, somebody was speaking about it, and they told me that at the Constituent Assembly stage, when the Constitution was being drafted, over 60% of the members were lawyers. They came from the legal fraternity. They are the people who sacrificed for the country. And number of lawyers who went to jail for the country is enormous. I mean, we can go on recounting it right from the first president of the country, Bapu Rajendra Prasad onwards. They were all lawyers. Now, from there, we have come quite a distance away now. We are now past 7 decades of being independent country. And where have we reached? We need to introspect or do, as we call it, Simhavalokana. When you do that and look at these, what shall I say, nuggets of wisdom that we have, let us see what is a lawyer expected to do. Now, if a client comes to you, do you judge the client and find out whether what he's saying is the truth or what he's saying is not believable? Or do you have to look at what he tells you, accept him at face value, and then look at the law and decide what the law can help him? Supposing a client comes to you and says, sir, I've just murdered somebody now. I need you to help me to prevent miscarriage of justice to me. What is the role of the lawyer? The role of the lawyer is to find out to what extent the law can come to his aid and propound his cause in court. That is exactly the role that he has to play. He doesn't have to judge, because the role of judging is not left to him. It is left to the judge who's going to hear the case. Now, we all know the famous Indira Gandhi murder case. One of the accused persons consistently was convicted by the lower court and also by the high court. But the Supreme Court reversed the conviction and said, no, he is not guilty of conspiracy because there is no evidence of conspiracy. So what is it that the lawyer is expected to do? The lawyer is expected to assist the client to the extent that he can assist. But does that mean that the lawyer should go and say, create a document? Many times, clients come and tell you, sir, actually, this did not happen like this, but I want you to protect me. Then what does a lawyer do? Does the lawyer tell him, okay, if it didn't happen like this, you cook up one document, get one antedated stamp paper, forge some signature, and we'll file it in court, and let us see what will happen. The law's delays will take its own time. And for all you know, your case they may accept your argument also. That is also possible. But is that the role of the lawyer? Then you're forgetting that your duty is Nishkama Karma. Nishkama Karma means you do not have any role in the success of the case. Now, unlike in many jurisdictions where champerty and maintenance, they were offenses under English law, which has totally changed completely. Of course, in America, it was never recognized that a lawyer should have nothing to do with the result of a case. Whether the person wins or lose, his fee is to be fixed. He cannot have a contingency fee that if you succeed, I get so much percentage. If you lose, I don't get any fee. Such a contract is invalid and illegal in India. But in many jurisdictions, they accept such a contract. So what happens to lawyers is when you enter into such a transaction, it ceases to be a profession, it becomes a business. That means you get interested in the result of a case. Now, many times young lawyers come to tell me, sir, I've accepted this brief, and the client has told me that if I succeed in this case, this litigation relating to 5 acres, I'll give you 1 acre of land. And the lawyers think that that is something possible to accept. So oftentimes I have to chide them to say, look here, that means you are going to step into the shoes of your client. You are yourself going to become a client. You're going to lose your objectivity. You're never able to present your case in a fair and a proper manner. That should never be the case. This is the situation that we are now faced with. It's a very hard fact. Same thing with motor vehicle cases. We hear this abuse quite often times. Lawyers go, they call them ambulance chasers in America. They call them more or less the same here. When an accident takes place, the police station, when it's told, will call up a certain group of lawyers and say, sir, some cases happen like this. I'm sending the client, you give me so much percentage of my cut, and you take the fee from him, you'll get a good fee, and do a contingency fee of 50% of the amount that is paid by the insurance company. These kind of things happen. So what I'm saying is, of course, the courts are trying to see how this should be prevented, but nevertheless, it is happening. Now, you see, one important aspect that we need to bear in mind is what is our duty? In the past, lawyers accepted that they had a very important duty towards their client. they also had an important duty towards the state and the court. Now, in many cases, nowadays it's becoming less and less, we hear of it in court. Many times I remember when we are about to present a case to court, I would always ask my assisting lawyers and colleagues in the office, please tell me which are the cases against this proposition, because I need to know. And once you know it and you feel that there is a judgment which is likely to be used against you, which is possibly there is an answer to it, what is your role? Should you wait and see? Other side lawyer probably might not have done research. He doesn't know that the judgment is there. What is your duty? Your duty then to the court is to point out to the court that there is such a judgment. Apparently, it seems to be against me, but it is not so. This is the reason why I'm saying so. And you must use your skills of advocacy to convince the court that this is not a judgment which you should follow. This is the judgment which you should accept. Now, what I'm saying is that the minute you have anything more, imagine a case of a lawyer who has a stake in the end result of a case. Will he be able to discharge his duties in this manner? Will he be able to act in that impersonal, impassionate manner? As you know, even in the medical profession, there is an unwritten code of ethics that if it is somebody which is close to their family, blood relative, the doctor who's treating him, he or she will not operate on that person. Will take the advice of somebody independent and impartial. See, this is what is expected of the legal profession. Now you see how far have we come in terms of what are the standards that we have. There are cases and cases that come our way. And some cases we find that the client has a very good case. At the same time, the client finds that he is not in a position to actually pay your fee. I remember two episodes in the life of my legal profession under my my father late, Mr. Sundar Swami. One was a case where there's a company dispute. The man was, they were running a company together, two of them, and they fell out. And an attempt was made to remove this client who came to us from his office of directorship. He had a young family, two young daughters. He was living in a rented house. And one of the things they did was they came to cut off his electricity and telephone connection from his house. Now, at this juncture, the client comes. And of course, we did some preparation. I prepared everything and went to senior. He had a look and he said, yes, this is the right remedy. We'll file a petition for mismanagement operation. And then the client came and said, sir, I have to pay you some fee. So we indicated some fee. And he sat down and said, sorry, I cannot afford to pay you a fee. I'm afraid I will not be able to afford you. So I will, go to some other lawyer. Then my senior said, no, what is your problem? If you have a problem with fee, I never told you that you have to pay your fee now before we can do the work. And he called me aside and he told me, he said, see, don't ever talk of fees with this client. He is in trouble. So let's not talk about fees and cause more distress to him. Let's get the case going. We filed a case. The most eminent lawyers from the country appeared against us. The case went on and on and on for a long time. We got a good interim order. Then the matter went right up to Supreme Court also. But the client, we never asked him for any fee. Now he had started another industry. Sometime later, he came to meet and then told my senior, sir, sorry, I did not give you fee. It is my duty to give you some fee. And I want to tender some fee. So senior did not even ask him, what is the fee? What is it? He said, see, if you want to give, you may give. And left it at that. And he never actually then said anything else to him. This is one episode. Another episode, which I did not know about, which I have narrated it in my book called The Story of the Clan, A Legacy Untold, which was published recently a few months ago. It's also available for those who are interested in reading it. It's about our family, about profession, about seniors, about so many other things, spirituality, and so on. One other episode, which currently a person who holds the office of a Chief Justice of High Court today, he told me, I didn't know about it. A few years after this gentleman left his senior's office and was practicing, he came to my senior to entrust him with a brief. And when senior looked at the papers, accepted the brief, and then told him, okay, we'll get ready with the matter. The papers were got ready. And then this lawyer, this was the first case in which he was engaging a senior advocate after he had become independent. So, you can just imagine his youth, his inexperience, and his trepidation with going to somebody like who was a colossus in the field of law. There was nobody who didn't know my father's name. So he with the great trepidation, he asked him about fee, and senior indicated some fee. After 1 week, he came and gave the fee and went away. Few days later, senior sent for him and told him, I received the fee. Did the client have any difficulty to pay the fee? So then he said, I don't know, sir. I'll have to inquire. So he went back, made inquiries, and next promptly he came back and told my senior, sir, he wanted you to appear in this case. It's a big land dispute, but he didn't have money. So he has pawned his wife's jewelry and he has raised this money and given it to him. The minute senior heard it, he told him, you do one thing, you come to my office tomorrow. I want to give you some instructions. Then what happened was that a few days later, the gentleman, the lawyer came back, and the lawyer brought that money, and senior had the money ready and gave it to him and said, that I am not interested in keeping this money. Please return this money to your client and tell him that he should repay the loan and not pledge his wife's jewelry. So he was very apologetic. He took the money, then returned it. The wife's jewelry was done, and then fees issue was not discussed. Matter ended. They succeeded in the High Court. Matter went to Supreme Court. We succeeded in that case. Some 6-8 months later, that client came to the office to meet senior and fell at his feet and told him that, but for your gesture, I don't think this result would have followed. It is only because of the attitude that you showed that I have all my problems in the life are resolved. Now I'm giving you these two episodes as a narration for us to understand what is our duty, to whom do we owe our duty. You see, money is not everything in the profession. Of course, if there is a good case, you're spending quality time, you're going to be burning the midnight oil, because as all of us know, there is no Saturday, no Sunday for lawyers. Every day is working day, and Sundays are more of a working day than any other day, because except going to court, we're doing everything else on Sunday, doing research, reading files, getting instructions, meeting sometimes clients or juniors. This is how our profession works. So in this situation, one argument that can be used against us is, can you really afford to be like this? In this context, I remember one episode from Mahabharata. After her hearing about the death of all her 100 children, she was asked, what is this? What has happened? How did this happen? So Mandari replies to say, Yato dharmaha tato jayaha. That means the adage is that where there is dharma, there will be jaya. Now, in a situation, if you keep this in your mind, is it your duty as a lawyer to do everything within your means legally and otherwise to see that your client succeeds? That means you are interfering with the process of dharma. Your job, your role, your stance should be to do everything within the four corners of law. You should not cross the parameters of law, of your propriety, of your morals, of your ethics. Once you do that, then you go back to the first shloka, karmanyavadikaraste ma phaleshu kadachana. That means you have done your duty, and a particular case, our experience shows many times when we examine a case, we think that, there is nothing in this case. And we tell the client, look here, there's very little we can say in favor of your case. So there's no point in filing a case. Sometimes the client will accept the advice and go away. Many times the client will tell you, no, sir, I think, I have a case. I want you to please argue. You don't worry about success. I'm not insisting that you should succeed in my case. I have great faith and confidence in you and your abilities and in the law. So kindly accept this case and do your best. I'm not telling you to do anything unethical. Whatever best you can say in my favor, in my clients, in my case, please say so. And then we accept it and we start looking at it. And believe it or not, my experience has been, there are a number of cases, number of occasions, when what happens is that the point which we thought was going to be against us is something which the judge thinks differently. The judge thinks, yeah, there's some point in what you're saying, this is something which we need to look at. And therefore, I think this case requires some relief, and you get relief. On the other hand, the other end of the spectrum is, you think you have a fantastic case. and you go and appear in court, and suddenly it takes a different turn and the case gets dismissed. I still remember one case when I discussed with senior, I was to argue that case. He said, there's nothing you can say in this case. But I argued the matter. At the hearing, the learned single judge also thought there was nothing in the case, but I didn't let go. I made all the points. Finally, he reserved orders, and believe it or not, he accepted every argument that we canvassed, and our client succeeded. That matter went to division bench. For some other reason, in the division bench also, we succeeded. The matter went to Supreme Court. For a very strange reason in Supreme Court, the Supreme Court dismissed the special leave petition and our client succeeded. It's a big property in Bangalore. What I'm saying is this dharma which is there is not in our hands. Where there is dharma, there is jaya. That is ultimately the result. So as lawyers, I think, if you keep these 2-3 things in our mind, and we are clear in our thinking that our role is to do something right and to do what we can best to do for the client. Now, many times there is a conflict about what your role towards the court is. What is your role towards your opposite side, a younger lawyer? I still remember one more episode, which is again narrated in my book, which I actually saw happening. He was a middle-aged lawyer. His father was also a very senior lawyer, and he was much younger than my senior. And senior was appearing in a matter for the High Court in a disciplinary action against one district judge. This other gentleman, lawyer, was appearing for the district judge against whom some proceeding had been launched by the High Court. It was being argued on the judicial side, and the man went overboard. He probably, his client put all sorts of things into his head about caste and this and that, and therefore he made all sorts of submissions in court. Senior was very quietly following it. As soon as the court rose for lunch break, he came outside. He put his arm around him and said, look here, I know your father. I knew your father so well. You are a good lawyer. And why did you go overboard in this case? You are appearing for a client. Don't forget it. Your role is to do your best for your client. But that doesn't mean that you must cross all borders of or limits of propriety and dense decency and decorum which you should follow in court. After all, this is one case. You will win this case. You will win another case. You lose another case. This should not make any difference to you. Therefore, it is important for you to distance yourself from what your client tells you. Don't believe that everything which your client tells you is the gospel truth and that's what you should propound before the court. You must sift it. You must sift the material. See to what extent you must place before the court, how you should place before the court. If you have a legal argument, by all means, raise that legal argument, substantiate everything. That is the role that a lawyer has towards the court. And this is how, seniors used to correct the juniors. Many times we find judges are very intemperate. Judges, they talk, what should I say, sometimes in a very hurtful way. Sometimes just justified, but many times it's not justified. Sometimes judges ask questions which are absurd. In your mind, you think the judge is asking me this question. I mean, a first-year law student will know the answer to this question. What kind of a question is this? You will think in your mind. But should you say that to the judge? Or should you tell yourself that here is a case where it is my duty to tell the court what the law is. Whether he knew it or he didn't know it or he made a mistake is different matter. We need not harp on that. We have to tell the court that this is the law and this is all supporting it. This is the legal position so far as this is concerned. Then what do you say? Now, many times it happens that you canvass a proposition of law. I still remember that's also narrated. Justice Venkatachalaya was on the bench. After some arguments were addressed, in his characteristic style, he sat down, took off his glasses, and he addressed my senior and said, Mr. Sundarsamy, you have argued all this right. But for one moment, keep aside the argument and forget it that you are appearing in this case for this client. Please tell us, does a court become functus officio after it passes an order, meaning that it cannot do anything at all? That was a case where after a judgment was pronounced, an application was made to stay the judgment because it was a case of winding up. The division bench had affirmed the winding up. So we had argued, saying, no, you're functus officio and all that. Then when this question was posed, the question was posed to the senior as an officer of the court, as a person who is there to guide the court and assist the court to come to the right conclusion. So then he said, I have canvassed this. But I really, personally speaking, do not feel that that is right. Even after a judgment is passed, the court is not denuded of any of its powers, and it should be exercised in an appropriate case, I know. And he said, in this case, it is not appropriate because there has been some fraud, that so many factors were there. Therefore, you should not interfere with this, your own order, which you have passed. That is how it went. So I think, come to the conclusion of what I want to say, there are some takeaways that we have from our working with the seniors. And what I find nowadays is there are of course some exceptional juniors are there, younger members of the bar who have had the benefit of working, being under the tutelage of a respected senior in the profession. But many of them, they don't know the nuances of the profession. These are very important things, these guideposts for our conduct have to be maintained. And lastly, corruption is also something, if you have Nishkama karma when you're doing a legal profession, if the client comes and tells you that, look here, sir, I want to pay so much money to a judge. Please help me. Tell me if this judge is corrupt. Who is the guy through whom I should go to him? What should you do? What you should do is you should tell him, look here, you have come to a court of justice. Don't pollute the court. Don't corrupt the court. Don't corrupt the system. If you want to do anything like this, I'm not going to be of any assistance to you. And you should withdraw yourself from that case. This has happened in the past. It can happen now also, merely because we think that we can make some money. If you take 2 lakhs from a client and give 1 lakh to the judge, nobody will know. And I'll end with a lighter vein. Many years ago, I went to Jaipur for a law conference, and I was the speaker there. And after the speak was over, many people came to tell me, sir, we have a very interesting system here about corruption. I said, what is that? He said, after a case is argued and reserved in contested cases, I don't know how far this is true. I mean, I'm not casting any aspersions on any members of the bar in Jaipur or anywhere else, but I'm just telling you this is a story which I heard. Both sides will tell their respective clients, I want to take some money, and we have to give it to the judge. They'll both collect it. Neither of them will give the money to the judge. Judge will write some answer. Once he gives a report, the one who has succeeded, that money will be shared with the 2 lawyers. The one who has lost will return the money to the client. So what I'm saying is, these are things, in bigger cases, we are now thinking of cases which have thousands of crores at stake. What is going to happen if you don't maintain the purity of the system? All this is possible if you just keep reminding yourself that your duty as a lawyer is to be following the rule of Nishkama karma. Thank you very much. It was a pleasure talking to you all, and I look forward to some searching questions. Over to Keshav.
So, Nishkam, sir, we are here without any thoughts of why. I think so. Very enlightening, actually, very thought-provoking. So, like, too many thoughts in my mind personally, which have come during this class. Comments are also coming about how enlightening this session has been with you. And I'm quite sure that this is something which everyone will keep on pondering over, at least all of our team, all of our participants over here. So, answer, I am their representative only. So, whatever questions are there, everyone, I request you to kindly put before sir, if you want to do so right now. So in the meanwhile, sir, I'll. So there is this question from Miss Rashmi Singh Rana. Miss Rashmi, would you want to ask this question yourself?
Sure, sir. Sir, my question is that how far you consider that ancient legal system is relevant in this contemporary era, as you said in your communication that we have a very good legal system in the ancient time.
Yeah, I said, the answer to your question is they're certainly useful, certainly relevant. But the unfortunate part is, who has studied it? I have not studied it. I know just a little sprinkling of some things I know. I mean, the more that I have started reading in this COVID time, I've been able to spend more time on all this. But the more I start reading, the more I realize how little I know. There has to be proper study. Justice M. Rama Joyce, late Justice M. Rama Joyce, has written a magnum opus on the ancient Indian judicial system. And it's worth, it's a textbook which should be prescribed, I think, compulsorily for all the law degrees. I don't know what they're doing, but certainly there are principles. Like, if you go, this Yato Dharmas Tato Jayaha, this is the, what do you call, the motto of Supreme Court. Like this. And there is a book published by him about all the inscriptions that we find in Parliament, which are taken from different scriptures. It's amazing that all our major buildings that were built at the time of independence and even before that, they contain all these things. So I agree with you entirely that they are very relevant, and they had to be studied, and they had to be put into practice. In fact, there is one judgment of Justice Markandeya Kaju, where he says that this Mimamsa principles of evolving a theory is something which should be studied and applied to current legal thinking. I forget the citation of the judgment, but there is a judgment of Justice Markandeya Kaju in the Supreme Court.
Again, it's very intriguing how you bring such deep light to this subject, and how you have been able to correlate both the topics of Nishkam Karma and of legal practice. And truly very insightful, sir, with respect to how you've pinpointed so many observations as well as so many incidents and personal incidents, more so to say, and such relevance which can be inferred. And I'm quite sure that there is a lot which needs to be gone through it with respect to that. So there is this mental dilemma of what exactly is going to happen to the matter. And here, sir, this is a huge challenge, sir, because I remember you very explicitly mentioned that it's you just do your duty, that you go, you represent, and you represent to the best of your ability. But sir, there is this, I think, this doubt which always comes to our mind, which is that what is the limit of my ability, or what I have done? How do I decide that what I have done, that is the best which could have happened?
Yeah, I think the answer to that question is, again, you get it from the Taittiriya Upanishad. Yanyana vadhyani karmani tani sevitavyani. Swadhyaya pravachanabhyam na pramaditavyam. Swadhyaya is, you have got to continue to update your knowledge. In our small law office, we have about 20 or 22 of us all join up on one day. And each of the associates who are working there, they are supposed to read case law to update themselves. Each of them is given a few minutes time to present one case which they found was interesting, and present it in a concise manner. What are the facts? What is the law laid down? And it is for the benefit of everybody. Now, if you don't do this and leave everything, now I am up to date. I read whatever I think I should read. Okay. So I know whatever I want to learn. But what about the younger people? See, you always get doubt in a case like that. I still remember, if senior was there, whenever you had a problem, you would go to senior and ask him, I have a doubt like this, what should we do? And he would guide you. Now that, he's not physically around, what do? Many times when, of course, now in the last 2 years, I've not been going to court, but everything is virtual. But when you're sitting in the bar room, some young lawyer will come and ask you, sir, I have a problem. Can I ask you some guidance? Yeah, most certainly you may. And they will tell us, these are the facts, this is what happened, this is what happened. What do you think we should do? What is the right course of action? Like this, they take some guidance. And at least speaking personally, I've never said no to any lawyer. If he wants me to see the papers, I also tell them, you don't think about it as a brief given to me for which I'm going to charge you a fee. This is not a fee brief. This is a brotherly assistance which I'm giving you. If you want, this is my viewpoint. Like that, we tell him some case law is there. Many times we give them some authorities also in support of it. So what I'm saying is, see, a person who knows and he knows that he knows is a wise person. A person who does not know and knows that he does not know has chance of improvement. But a person who does not know and does not know that he does not know, there is no redemption for him. So you must get to the second category. You get a doubt, you are not sure whether you know it correctly, you know that you are not sure, you know that you don't know. That is when you have to do more effort. More swadhyaya has to be done. And always draw upon the seniors, at least in Bangalore and in the Supreme Court bar, I see many of the seniors, they don't hesitate to guide a junior. So I think that is something which is available, that guidance is available. It is for us to go and ask.
So truly, what has actually very remarkably come out through your session, I think, is that if we approach the seniors and if we approach the correct person for the correct guidance, then there is no chance of not getting the guidance, but eventually it all boils down to us how we translate into our own action. So, with respect to the books that you have written, so, if you can very briefly just tell us about those books so that we can also, and also where to find them.
Yeah. I've written actually 3 books. One is a commentary on the Shankaracharya's famous composition called Prashnottara Ratnamalika. It's a very short composition of 67 verses, which is in bullet form. And it's an English translation. It's available in Vedanta Bharati. There's another one was called Viveka Deepini, which is a more concise version of it, which has 37 slokas, where the religious part of it is taken out. And it's a fantastic, anybody who's interested in intellectual stimulation should read them. It's so beautifully written. And it's so concise and precise. That book was, English translation was translated into 10 Indian languages. And it was released by the Vice President of India in 2017. That is also available in Vedanta Bharati. The last book is a recent one, which is called The Story of the Clan. Now, this is how it looks, if you want to see the book. And it was released on the 20th of November last year. And this book is a story about 3-4 generations of our family. And it is not merely a family story. It is a book which contains a lot of things about Bangalore, how Bangalore was, how it developed, how the society was at that time. Then what were the societal mores, 50 years, 60 years ago, how societies lived, how families lived, what was the relationship between father, son, daughter-in-law, mother-in-law, daughter-in-law, father-in-law, all these things, the social milieu at the time is also there. Plus, there are a lot of takeaways from the legal profession, because I've said I worked under a senior par excellence. My grandfather was also a lawyer. There are a number of things about how they got involved in society. And there is my own involvement with many institutions which are doing some phenomenal work, particularly in the field of devotion. And I'm connected with the Satyasai Trust of Puttaparthi Satyasai Baba. We have hospitals, we have universities. There's quite a big account of everything that all these institutions are doing. The pioneering work which Vedanta Bharati is doing, the very interesting organization called Samskrita Bharati, which is propounding spoken Sanskrit in India, what they are doing. Like this, it's an anthology of everything, and whoever is ready to said that it is interesting. So if anybody is interested, that book is available on Amazon.
Great, sir. So I will also mention I'm getting requests to mention the names of the books on our group as well. So I will just mention the names, the titles, as well as I will share some links also.
Yeah.
So anyone who is interested would most definitely find these very intriguing and interesting, considering, sir, how in depth your knowledge it actually comes across, sir, and it's a very wonderful vibe that you bring. I'm quite sure to the honorable courts also, whenever you're presenting, how it would most definitely it would be impactful. So with that, I think the time is up, and I would not want to unnecessarily hold you back for longer, but most graciously and so, with the humblest respects from our side and on behalf of the entire participants who have been able to join us today, we thank you, sir, from the bottom of our hearts for sharing such insightful and such deep knowledge with respect to how we should be able to conduct our practice without taking unnecessary stress, and where exactly to draw the line. This is what I have personally been able to gain the most from this particular class. That it's not that I have to just keep running till the time everything goes. I have to do my best to the best of my ability with all due guidance from seniors whom I can possibly gain whatever knowledge. And rest, sir, as you very, I think, diligently put it across to us, is destiny, that you just don't know. When you feel that the matter is, that you're very confident of the matter, you just don't know how the judge would look at it. And when you feel that, it's an entirely lost cause, at that point of time, also how events play out. And so we're just very grateful. And on behalf of everyone, sir, I thank you once again, sir, for taking this time.
You're welcome.
One, one more thing I would like to give to this platform. As far as learning is concerned, learning physical courts are very much necessary and essential. Many a times we don't know the subject matter. If the court which are taking an assignment of that particular subject matter is taking up the cases on a regular basis, the junior lawyer should go and sit there and hear the arguments. Even after even hearing arguments teaches a lot.
Yeah, I
that
agree.
that is not possible in the e-court and virtual courts. I have completed 10 years practice, but whenever I used to visit a high court and I am in the high court, I used to attend the courts and sit in the courts and hear the arguments of all the senior counsels and advocates, those who are specialized in the subject matter. So that also helps us a lot, because they are in a momentum and they are in the flow, and they touch the each aspects of that particular subject matter.
Correct. Yeah, there is a problem, of course, if you see my book, there are episodes in that about my grandfather's time, how juniors used to go and attend whenever he was arguing cases. Even now, many people ask me, whenever I'm arguing an important case, my colleagues in the office, they know that I'm arguing. Some of them will join in and, watch the proceedings. Even in the virtual mode in which it is going, many of the courts are freely allowing anyone to log in. So I think, you can keep a lookout, and whenever you have time, a particular court, a particular subject, you can actually log in. In Karnataka High Court, there's no restriction. I don't know about the other high courts. You can actually get the login codes right from their website itself. And, the cause list shows which is what subject is being taken up. So if something is of interest and you have time, you can actually sit in the comfort of your house and watch the proceedings. And they're quite good. Now, this hijab case has created a record. Yesterday, I read in the newspaper that 6.4 lakh people watched the live telecast, the live webcast on YouTube. I was shocked. I was one of the counsel. I could not get into the court. They said more than 500 people have logged in. So they didn't log me in at all. So these are problems that are there, but nevertheless, I think, I agree with you that to some extent, physically being there, you will see the body language, you see how they are, addressing the court. All those things are important, which is important.
Because sir, at that relevant time, all the junior advocates, mid-junior advocates, senior advocates, upper counsels, all are in advocate mode.
Correct.
The mode is very much essential.
Correct.
When we come to the home, we come into the home mode. When we are outside and doing casually something, we are in that mode. And when we enter the court, we come into an advocate mode. So that mode is very much necessary.
But what to do in COVID times, you have to manage. That's all I can say.
Yes, sir. Yes, sir.
Anyway, nice. Thank you.
Good afternoon, Keshav.
Yes, sir. Sir, that was Advocate Abhishek Singh from Bombay High Court. And sir, now this is Dr. Sai Kumar Pathudu.
Yeah.
Sir, he is.
I want to tell only one thing. It was an excellent speech, and outside the jurisdiction, Nishkama Karma, which is. But sir, I'll tell you one incident where Sri Ravi Shankar appeared before the small causes court. There were nearly hall was full. More than 2,500 advocates were there. So after he concluded speech, they have asked advocates immediate task. What should we do? So combining with your Nishkama Karma principle, the Sri Ravi Shankar said to the advocates, only 10% of your work, legal work, should be done free of cost to the poor and needy. That is. Then, judges felt that they remained silent, they should not ask. So one of the judges, like you, got up and asked. He said, please advise us also something because you advise the advocates. So Sri Ravi Shankar said, the judges got beautiful discharge of duty of delivering justice, administration of justice. Only they should accept and apply the principle of delivering the judgments from their heart rather than mind. That's all. This I want to add.
Yeah. Yeah, I think so. Shri is a very interesting person. Actually, he only released my book, the last book. My wife has written another book. He released that called Veda Kusumanjali some years ago. I've had the great privilege of being blessed by him for more than 40 years now. So the thing is, this 10% rule, I think only one point I'd like to clarify. I don't mean that lawyers should do free work. That's not what I'm saying. See, Nishkama Karma doesn't mean that you do all your cases free. My thing is, you should do every case for money only. You should take a fee, whatever is commensurate with it. But whenever a client comes who is not in a position to afford your fee, and you are in a position to do the job, don't make fee a pretext and say, no, if you don't pay me fee, I don't appear. You should not do that.
I agree, sir.
Second thing is your mental posture. When you do a case, okay, you have most senior advocates will charge a particular fee for appearance. It doesn't mean that if you pay that fee, the senior advocate should do everything illegal to somehow make his client succeed. His job is to do his best. And that's all there is. So you, as a lawyer, we should not even look at the end result of a case at the time you're doing the case. That's what I mean.
Yes, sir. Rightly covered the ethics of profession also.
Correct.
We have covered.
Yeah. Thank you.
Thank you.
So, Naganand sir, it has been a very enlightening and a very, I would say, memorable class with you. And I'm quite sure that this is the kind of thing I think, sir, personally, which everyone requires, because it needs this profession. So I was reading this article today itself by Honorable Justice Sanjay Kishan Kaul, which was on mental health, and how it actually mentioned that there is a study which says about 45% of advocates are suffering from depression, anxiety, or other related issues. And that was very startling, sir, to me, because everyone is actually, again, from the initiation of the profession itself, and I think up till whatever time one gets to practice, a person is consistently in the process of everything is unknown. So there is nothing which is certain in this particular profession. It's all uncertainties. What I have been able to gather from whatever little experience I hold. And so, with respect to that itself, I think at least there is some clarity with respect to how one may be able to approach their practice without without any thoughts of probably getting lost, or at least trying to find oneself, or at least having some answers with respect to how one can do, or what one needs to do, or how much one can particularly address in one particular time frame. And that's, I think, so that's about all the clarity which a person needs to be able to clear their minds. And so you have very truly and very diligently and to the point, so you have addressed all of these concerns. I am hopeful of which will help many other advocates who will be referring to these videos in the future also. And yes,
Yes,
sir.
our suggestions also put it to sir that this last we need to rush to senior, but all the juniors are not available. So this course should become practical, that in 5 years course, 1 year practical experience in all courts, one month, 1.5 months. Kindly ask sir to, Naganand sir, to put across the bar and put across to PMO or law and judiciary that law course should become practical course. Sir, your response.
That's a larger issue, you know, there are so many issues there. There is a committee headed by Justice A.P. Mishra looking into that. And the Supreme Court is also seized of it about legal education. But really, you know, it is, see, when I remember about 20 years ago, they had this system of 1 year internship after you finish law. So there was a lot of agitation for that. And after some years that was accepted and it was withdrawn. Then initially there was no bar exam. You did not, once you qualified as a lawyer, all of us as we qualified, we can go and enroll. Now there is a bar exam. Now for bar exam also there was litigation, this, that, everything. Finally it has come to stay, but COVID has changed everything again now. So what I'm saying, you know, this is entry point. But I am now concerned about those who are already in. See, those who are already in what they see in all professions, they have a continuing professional education requirement. Take the medical profession in America. Even if I'm the topmost surgeon, I have got to go through that CPE. Same thing is there in chartered accountant. It's there.
Every 5 years you have to appear exam in USA.
Not exam, not exam. No, there's no exam. What it is, there is some courses that you have got to attend and you have to get some credits. Same thing is there in Institute of Chartered Accountants in India.
Correct.
Up to age of 60 years, you have got to meet your requirement of CP. Otherwise, your certificate of practice will not be continued. After 65, they're given complete exemption. So like this, you know, they must do something in legal profession.
I agree, sir. I agree.
that's-
I request you to take up this
Yeah.
at the 5 years 1 year practical course. You can definitely extend your helpful hand.
I am not
Upcoming
such a
charge
great
will
person
more.
in the powers that be. I'm a simple senior advocate, works here and there. That's all.
Sir, can we know the name of the ancient legal system book you mentioned, sir? So can you mention it once more, sir?
1 minute, yeah. I have it somewhere. Let me just see if I can find it. 1 minute.
Acha. So just give us the name, no, sir? Name and author.
Actually, I don't remember the full name. It's a long name. The author is Justice M. Rama Joyce. I will share the name with Keshav. Maybe he can share it with your group. Of all the 3 books that I mentioned, including Justice Rama Joyce's book, I will share the complete details, publisher, everything.
Yes, sir. Kindly have it sent on a WhatsApp community site,
I'll
sir.
send it to Keshav and he should do that.
Yes, sir. We'll really read those books.
Sure.
Most definitely. So, sir, as I said, sir, what you've said today, sir, all of these are things which people will keep on reflecting over and over. And so, most humbly, so I know for sure that what I had asked you for, that you have given me more than that much time.
Thank you.
We'll request your kind permission to close the class today. And thank you so much, sir, for taking your time out and for addressing us on this very unique topic.
Thank you. All the best to all of you. And thanks to Keshav for the initiative that he has taken in getting this group together. It's very good.